This is Colin O'Keefe for LXBN TV. Might telecommuting be considered a reasonable accommodation for people with certain disabilities? A recent ruling by the Sixth Circuit says that it very well may be. Joining me now to explain the case on hand and what it means for employers is attorney Robin Shea. She's with Constangi and author on the superb blog, The Employment and Labor Insider. Robin, first, can you explain the basics of what happened here, and then, how did the Sixth Circuit's ruling exactly play out?
Well, the EEOC sued on behalf of a woman who was a resale steel buyer for Ford Motor Company up in Michigan, and her job involved a lot of computer work and telephone work, but there was also a fair amount of FaceTime that was required as part of that job. And she had irritable bowel syndrome, and apparently a pretty serious case of it, where she would have very severe flare-ups and unpredictable flare-ups and was actually incontinent. So she never knew when she was going to have an attack. And mainly, I think because of the embarrassment and her need to get cleaned up if she had an accident, she had requested to telecommute for 4 days out of a 5-day week. And Ford said, no, you can't do that because we need for you to be having this FaceTime with our suppliers. But we will talk to you about some other alternatives. And the alternatives that are reported in the court decision were moving her office to a location closer to the restroom. And the other alternative was to let her transfer to a different job that might be more suited to telecommuting full-time or almost full-time than the one she was in. And she just refused to consider any of those alternatives and insisted that she wanted to telecommute 4 days a week. The district court in Michigan granted summary judgment to Ford and said she wasn't entitled to this. But the EEOC took the case up to the Sixth Circuit, to the U.S. Court of Appeals for the Sixth Circuit, which hears appeals from Michigan, Kentucky, Ohio, and Tennessee. And a 3-judge panel of the Sixth Circuit found in the EEOC's favor and said that telecommuting was a reasonable accommodation, and which wasn't a big surprise to anybody who practices in the area of employment law. But the other, I think, noteworthy aspect to the panel's decision was that they said that as technology has progressed over the last several years, employers need to be much more open to considering telecommuting as a reasonable accommodation under the Americans with Disabilities Act.
Certainly. And then second, what's the impact of this case? You recently said or wrote on this case that telecommuting could be considered a reasonable accommodation, but not in this suit. Why is that?
I'm hoping that Ford will seek review from the Sixth Circuit, or at least win the case at trial. And I'm generally very much in favor of telecommuting as a reasonable accommodation, and even as not a reasonable accommodation. I think it's a great thing that we have the technology to allow us to do that nowadays. But in this particular case, I think Ford met its burden of showing that this was not a job where extensive telecommuting, like 4 days a week, would be suitable because of the amount of FaceTime that was required. The other thing that especially jumped out, there were a lot of things that jumped out at me about this decision, but the other main thing was that if her episodes with this irritable bowel syndrome were so severe that she could not work at the office, even being close to the restroom, then I'm wondering what would have been solved by allowing her to telecommute for 4 days a week. There was evidence from the company that she needed certain information to be able to do her job well. That was only available during regular business hours. So if she had to take a lot of breaks during a normal business day, she was going to have to make up that work after hours and would not be able to do a good job because she wouldn't have access to the information she needed to do her job. So my takeaway from it was, what was this 4-day-a-week schedule going to solve in her case? And I don't think the court gave enough credit to Ford's evidence that this just really wasn't going to work in this situation. And we tried to accommodate her in other ways. She refused to consider it. And, we've met our obligations.
Absolutely, it's a very interesting case to take a look at. And then, as you mentioned, technology is making telecommuting much more easier as time goes on. So it's going to be an interesting field to watch to see just how much this is regulated and then accommodated. Once again, that was attorney Robin Shea. She is with Constangi, and you can read more of her insight on this case and others in the labor and employment space at employmentandlaborinsider.com. Thanks for joining me today, Robin.
Thank you.